Welcome to our second lecture covering Chapter 5 from our textbook. The topic for this chapter is mutual assent of the parties. So let's begin. We talked about the definition for mutual assent. It is a meeting of the minds. And now what we're going to do is we're going to talk about the 6 ways that we can destroy mutual assent. Obviously, we don't want to do that. It's something has gone wrong if one of these things shows up in your contract negotiations. The things that we talked about during our first lecture is fraud, misrepresentation, and mistake. Fraud is an intentional lie that one party to the contract makes to another. Misrepresentation is an innocent misstatement of fact, but a misstatement of fact that the person who made it should have been more careful about, and the other side relies upon that to its detriment. In both cases, and in fact even in the third case, the mistake or the error has to be material or significant to the deal. In a mistake situation, both parties, well, if it's a mutual mistake situation, both parties are mistaken about a material fact. In a unilateral situation, only one party is mistaken. So in all 3 of these, we have a situation where there has been a wrong understanding about an important fact to the contract. And again, they reflect 3 different ways, or I guess 4 if you consider mutual and unilateral mistake to be different types of ways, where that misunderstanding or wrong understanding has occurred. So these are united in a particular way. During this lecture, we're going to talk about our last 3 ways that we can destroy mutual assent. The first is duress. The next is undue influence. These 2, duress and undue influence, are kind of closely aligned. And then we have unconscionability, which is kind of an umbrella concept. We'll talk more about that as we go forward. Let's just do a little bit of a refresher on this. As you know, the elements to a contract are 4. So these are the elements. Let me just write here elements so we can have that little reminder here. So we're going to talk about the 4 elements that we need in a contract. If we're missing one of these elements or these ingredients, we don't have a contract. The first is there needs to be an agreement. The second is there has to be consideration. Both parties have to provide it. The third is we need legal capacity, and the fourth is we need a legal object. We don't need to have a writing in most cases, so this is not an element of contract. Our agreement element has 3 sub-elements: offer, acceptance, and mutual assent. If we are lacking an offer, we don't have an agreement. If we're lacking an agreement, we don't have a contract. If we have an offer but no acceptance, we're lacking an agreement, therefore we're lacking a contract. If we have an offer and acceptance, but somehow or another the acceptance does not qualify as mutual assent, then we are lacking an agreement and we don't have a contract. So it's important that we have all 3 of these. They're all essential to having an agreement. And again, this is the topic for this particular chapter. So I'm going to fast forward to our last 3 categories. We're going to talk about duress next. You can see this is an example. Oops, let me go back here. This is an example of a duress. This person has a knife being wielded around him and a gun being wielded around him. Under these circumstances, you can see he's pretty stressed. He's going to sign whatever is put in front of him, no matter what it says. He wants to save his life, and so therefore he'd be willing to sell his billion-dollar business for a single dollar, or anything that he might be required to do, not because he thinks it's a good deal for him, except it is a good deal for him and that he keeps his life, but it's an unlawful level of pressure that is being applied. And we have another version of this. In this case, we have a woman who has a gun being pointed at her head. Again, she's going to do whatever she's told, even if the terms of the contract she's signing are not advantageous to her. So here's our definition of duress. Again, it's in red in bold, so we know it's one of these terms that we're responsible for on quizzes and tests. Duress is coercion applied for the purpose of compelling a person to do or refrain from doing a certain act. So for it to be duress, we need to have 2 elements. It has to be wrongful. So the person exerting the duress has to be, the act of duress has to be wrongful. So if I were to say to you, I'm going to sue you because you breached contract, that might be very worrisome to you, and that might make you be willing to sign lots of different contracts. But if you in fact breach the contract, or have a reasonable belief that you breached the contract, my offer or my statement that I'm going to sue you isn't wrongful. I have the right to sue you under those circumstances. So I have to be doing something that is wrongful. But doing something wrongful isn't enough in and of itself. Let's say I threaten to sue you, but you haven't breached the contract at all. But you are a billionaire, and all I could sue you for would be maybe $10,000. Well, under those circumstances, I'm not really applying an extreme amount of pressure to you. Whether you win or lose a lawsuit, your life is going to go on pretty much as it is. So even though the duress I'm applying is wrongful, it isn't so extreme that you would lack free will. Now, if you are, say, a middle-class person and all the assets you have in the world is $100,000, and you might lose that $100,000 if I win my fake lawsuit, well, then that would be a situation where I'm acting unlawfully and I am applying extreme duress that could make it seem like you did not have free will. When we consider the concept of free will, it's kind of an interesting idea. It has religious connotations to it, perhaps, but it also has legal and philosophical connotations. There's a lot of discussion out there in philosophy about whether any of us have free will, but let's not get too philosophical in this area. A way that I would have free will, for example, would be when I drive to work. I can go down Coit Road, or I can go down Preston Road to get to my office. I get to choose which one makes sense to me. That would be an example of free will. But when I get to, I'd go down El Dorado. I go west on El Dorado, and of course I pass Coit first. But let's say Coit is blockaded, and I can't get on Coit from El Dorado as I'm traveling west. Well, then I don't have free will. I can't make that choice. So I'm obviously going to go down Preston Road. So that would be an example of how I've lost free will. But of course, maybe they've closed Coit at that intersection because there's been a bad accident, or maybe there's some road construction going on. So it doesn't mean that there's anything wrongful going on. It just means that I don't have that choice available to me anymore. So that would be an example of free will that I have when I can go either direction, and I don't have it when a particular option is removed from the list of things that I can do. So here's some examples of things that would qualify as duress. Threats of violence, again, the gun to the head, the knife in the arm, the balled up fists in your face, that could be another type of violence. A threat of physical imprisonment. You can see here in this scenario, this guy is being driven away somewhere. He's being taken to some place that he probably doesn't want to be. That would be an example of physical imprisonment. A threat to take or keep personal property. You can see here that this man is holding onto his briefcase very tightly. Maybe they're going to take that away from him. Maybe there's something in it that matters greatly to him. That could be an example of personal property. Or a threat to breach a contract. Now, these first three things are crimes. It's a crime to threaten violence or to threat physical imprisonment or to take away personal property. It's not usually a crime to threat to breach a contract. So when we say something is wrongful, we're not necessarily saying it's criminal, although many times it will be criminal. It just has to be perhaps civilly wrongful, such as breaching a contract. I don't like to spend a lot of time on this next section because it's not something that would likely work in Texas. This is kind of duress light, so to speak. You've heard of, Pepsi Light or Coca-Cola Light or whatever. Well, this is the equivalent. This is what we call economic duress, and it's a lighter version of duress. It's not quite as difficult to prove, but I don't think that necessarily Texas courts would be overly impressed by it. Let's just consider it for a second, although again, I don't want to put too much emphasis because this is where most of the action is with duress. So for an economic duress claim in jurisdictions that would consider it, there needs to be some kind of wrongful action, something like one of these activities, and it has to cause some level of financial hardship. So we've addressed the wrongful part. Where we're being a little bit more forgiving, quote unquote, in terms of duress is the extreme part. So an injured party acts against his or her will, and there's an economic detriment, and there's no other legal remedy that's available to the wrong person. But it may not be so extreme as we might see in some of these circumstances. So again, that's where I'm calling it duress light or economic duress. But again, most of the activity, the part that we're going to focus on are these traditional categories of duress. So that is our fourth category. Now we're going to talk about undue influence. These two often are confused with one another. Just like fraud and misrepresentation are kind of sort of the same thing. This is knowing, this is innocent. Well, duress and undue influence are also kind of similar ideas. So I'm going to talk about what undue influence is and then contrast it with duress. I'm also going to compare undue influence to misrepresentation because there's some connections there too that I think are helpful as we put things together. And this is our image for undue influence. We can see we have the puppeteer kind of pulling the strings of various people. Maybe they're not even aware that their strings are being pulled, but they are being driven or pushed in a certain direction to take actions that maybe aren't in their best interest. That's what we're talking about when we're talking about undue influence. So here's our definition. Again, it's in red and bold, so you want to pay attention to this. I added this part, so be sure that if you're looking at the textbook version, you consider adding this to your notes so that you'll have this additional part that's important. Arising out of a confidential relationship. And let's pause here and let's go back and look at fiduciary. We talked about fiduciaries when we were talking about misrepresentation. And a fiduciary, again, is a person who owes another person utmost good faith and loyalty. A fiduciary relationship is a relationship that involves a fiduciary, and the fiduciary is the person who is obligated to act with that utmost good faith, honesty, and loyalty towards the other person. Now we're going to talk about a confidential relationship. The category of confidential relationships is bigger than fiduciary. A fiduciary relationship is a confidential, go back here, is a confidential relationship, a relationship based upon confidence. And let me be here. A lot of times when we use the word confidential, we mean secretive, but here we mean a relationship based upon confidence or trust. So certainly confidential relationships would include fiduciary relationships, but they would also include relationships that are a little bit more informal, that aren't quite as legislated and regulated as fiduciary relationships are. So this is a bigger umbrella than the narrow category of fiduciary. So we're talking about confidential relationships arising out of a confidential relationship, inappropriate pressure exerted on a person for the purpose of causing that person to substitute his or her wishes for another. Okay, so we're going to call the caregiver A. This is the dominant person. And then we're going to call the other person B. This is the subordinate person, the person in a weaker position. So A applies the pressure to B for the purpose of causing B to substitute A's will for B's will. So let's go through an example of how that might play out. We have here an elderly woman, perhaps she's ill, perhaps while she's still legally competent, she is maybe in the early stages of an illness that is causing her to be less clear-headed. Maybe she has not a severe form of dementia yet. And she has a caregiver here. Perhaps this is her nurse who lives with her, who bathes her, who feeds her, who provides company for her, who helps her out of bed and takes her to the park and those types of activities. This woman is very dependent upon this woman, and very likely this woman has real affection for her caregiver and feels a high level of dependency. There may even be some element of, well, I don't want to get my caregiver mad at me because maybe I won't be given as much food to eat, or maybe when I need to go to the bathroom, she won't be quite so quick about coming to help me with that, or something along those lines. So the relationships can be complex in this area. Good close friendship, but also some fear and imbalance of power, so to speak. So that would be one category. And you could see in that situation that this elderly woman, who may not be fully sharp mentally, she's developed this close relationship with this caregiver over months or years, and this caregiver presents something for her to sign. Well, this lady is very likely to say, of course I'll sign it. Why wouldn't I sign it? You take care of me. I trust you. And so she goes ahead and signs something that isn't to her advantage. Now notice in my scenario, I don't have this woman telling any lies. Obviously, if this woman would have told lies, then we might be in a situation of fraud. Or if the woman made innocent misrepresentations, we might be in a misrepresentation situation. If she actually said to the woman, I won't give you your food or your medicine unless you sign, then we'd be in a situation of duress. Now, this is a more subtle situation where she's maybe encouraging or coaxing or constantly bringing it up in a way that weakens the resolve of the elderly person or the ill person. And so it's behavior that doesn't fit into necessarily these categories, but the kind of the spirit of the behavior is consistent with these categories. And again, this would certainly, undue influence situations can arise in that fiduciary situation. So an attorney, for example, who is advising a client about what business entities he ought to invest in, if suddenly the attorney is suggesting the attorney's own businesses, even if he doesn't lie about it, even if he doesn't misrepresent things, if he's in that position of trust, he may be exercising undue influence over his client. So that could be another example. So this is how undue influence potentially can work. Now, this doesn't mean that an attorney or a fiduciary can never enter into a business arrangement with a client, but it certainly means that those types of situations have to be very, very carefully thought through. There are real landmines out there. And of course, part of it is inappropriate pressure. Obviously, if this woman, let's say that the elderly woman had her children very involved in her life, and if this caregiver dealt also with the children and talked with the children, this is what I'd like your mother to sign. These are the reasons why I think it's in her interest. And the children said, yeah, I think that's right. You know, and she didn't pressure the woman and didn't mention it all the time. And there could be ways that it could still be possible for there to be this business relationship, but it's something that has to be thought through very carefully. The part you want to avoid is the inappropriate pressure. So that is our discussion of undue influence. As I said before, it's similar to duress in that pressure is being applied, but it doesn't have to be nearly as severe. We're really not talking about extreme action. We're really not talking about depriving that subordinate person of his or her free will. And we're not even necessarily talking about something that's really wrongful. But duress doesn't require that special relationship, whereas undue influence does. Similarly, it has some similarities with this misrepresentation. We were talking about the fiduciary situation where there can be a misrepresentation. Well, you could say that when you are providing support for an elderly or ill dependent person, even if you aren't directly telling lies, let's say this deal that this woman is wanting her patient to sign is very favorable to the caregiver and very much to the disadvantage of the ill person. Well, she may not say anything false, but the whole nature of the relationship may suggest to the elderly woman that this nurse would never take advantage of her. And so in some sense, there is kind of an implicit misrepresentation going on under those circumstances. So you can see how an undue influence situation could be analogous to duress, also could be analogous to misrepresentation. Okay, so let's go on and talk about our final category. We've talked about fraud, misrepresentation, and mistake in our first lecture. We've talked about duress and undue influence today, and now we're going to go on and talk about unconscionability. Some people consider unconscionability not to be a way that mutual assent is destroyed. It doesn't fit quite as readily as these others because honestly, these other ones is pretty obvious. In these situations, somebody really hasn't assented because they think facts that aren't true. In these two situations, somebody really hasn't assented because he or she is really being put in a very awkward, uncomfortable position. That's the only reason that they're agreeing. So these, it's pretty obvious how mutual assent doesn't exist. This one's a little bit more challenging to get a tight hold on from a destroying mutual assent situation, but you can make the argument, and I'm going to make the argument in just a second. So help me, wait with me as we go through this one. One of the things, and we've talked about this before, but let me reiterate it, is that parties to a contract have a duty to each other to act in good faith with respect to the other party. This is not an arm's length arrangement. This is a voluntary relationship that the parties are entering into. They have the duty to act fairly with respect to the other party. Now, this duty doesn't mean that they have to give up things that they don't want to give up, or they have to agree to terms they don't want to agree to. But it does mean that they ought to not be completely selfishly looking only at their own interests. And where we see this can become a problem is where we have unconscionability. So what is an unconscionable contract? And by the way, let me just make a point about unconscionability. We see the word conscience here. We know that our conscience is what kind of tells us right and wrong. Sometimes we might make a mistake, do something that's not very nice, and we feel bad about it. Criminals sometimes commit crimes and then they go in and confess it because they can't sleep at night because they feel so much guilt. So when we see something that is unconscionable, we're saying something that is something that is outside what a person's conscience should tell them that they ought to be able to do. It's something that is shocking. It shocks the public sensibilities, and it is unreasonably oppressive. I mean, this isn't just a really unfair contract. It's shocking. Think about that. I mean, how many contracts have you ever seen that are shocking? The whole notion that a contract can be shocking kind of tells you how really, really unfair it has to be before we even talk about unconscionability. So let's look at the definition again. Of course, the definition is in red, so we want to pay attention to this one for quizzes and tests. An unconscionable contract is a form of contract in which a dominant party, we're going to call this party A, just like we did before, has taken unfair advantage of a weaker party, B, and has imposed terms that are unreasonable and one-sided. Okay, this is a definition. I don't love this definition, but you know, it's the one we have, so let's work with that. There's a couple of problems with this definition. The first problem I have is that it's not merely unreasonable. I mean, that seems like a pretty low standard. There's lots of contracts that are unreasonable. Courts are not looking for unconscionability. They are loath to find it. Honestly, a judge's philosophy is, look, you're an adult. If you signed it, I'm going to bind you to it. Because guess what? If you don't like it, don't sign it. I'm not your mommy. I'm not your nursemaid. I'm not going to correct the mistakes that you made. When you're an adult, you got to suck it up and deal with it. That's the philosophy of courts. So no, a court isn't going to be there saying, oh, yeah, this isn't fair for you. I feel so sorry for you. Here's a lollipop. And yeah, you don't have to do that nasty old contract. No, courts aren't going to do that. 95 times out of 100, the court is going to say, suck it up, buttercup, deal with it. But every now and again, when it's really, really extreme, really, really shocking, and a lot of times when, you know, it's the widow, it's the orphan, it's the poor person, when that's the B, the weaker person, maybe the courts might be a little bit more inclined to do that. If you're talking, if a business is the weaker party, or a wealthy person who's just not as wealthy as the dominant person, the court's going to be hard-hearted. Grow up, learn from this experience, and move on. So this is a higher standard maybe than this word suggests. There's another reason I don't like this definition. That has to do with actually with this bottom part right down here. We say unconscionability can be two varieties. There's two flavors of unconscionability. This is sometimes hard to tell whether a particular contractual term that is unconscionable fits into procedural or substantive, but I think the concept is pretty straightforward. And really this definition focuses upon the substantive unconscionability more so than the procedural unconscionability. So this definition isn't quite as complete as I would like it to be. So we're going to talk a little bit about procedural unconscionability and then substantive unconscionability, and then we're going to contrast the two. So let's go to the next slide. So what is procedural unconscionability? It's a circumstance in which one part of a contract lacks, one party to a contract lacks a meaningful choice or assent to the contract. Key word here is meaningful choice. Imagine that you don't read or speak Serbo-Croatian. I present you with a contract written in Serbo-Croatian. You say, wait a second, I don't read Serbo-Croatian. I'm going to need to hire somebody to read this contract to me, or could you translate it for me? I'm like, nope, I'm not going to translate it for you, and I know you don't read Serbo-Croatian. You will have to decide whether to sign it in the next 5 minutes. What? How will I even find somebody who can translate this? Plus, the contract is 100 pages long. Even if I spoke Serbo-Croatian, I couldn't read a 100-page long contract in 5 minutes. That's your promise, not mine. You either sign the next 5 minutes or it goes away. You won't have the option to sign the contract. That would be procedural unconscionability. You may notice under these terms that actually the details of the contract are irrelevant. You don't even need, in order to prove procedural unconscionability, you don't have to even present any of the actual requirements of the contract. Other ways you can have procedural unconscionability could be, let's say you're blind and I refuse to have anyone read the contract to you, or you don't know how to read, or you don't have your eyeglasses, or the contract is written in a lot of legalese that's very difficult for a layperson to understand. Or maybe I am putting a high pressure sales on you. Maybe you're away from family and friends and I'm really putting the screws to you and, oh, you need to sign right now, you need to sign right now. And you're really, really stressed. That would be an example. In a really extreme case, that could be duress, but in a maybe somewhat less extreme case, maybe that's just unconscionability. Those would be examples of procedural unconscionability. So again, it doesn't mean when you have procedural unconscionability that the actual terms of the contract are so lopsided, although usually they are. Usually where you have procedural unconscionability, there's a reason that the person is putting so much pressure on the other person, because there must be something not quite right about the underlying contract. So a very common feature of procedural unconscionability is to have boilerplate language in the contract. This is very common, and boilerplate, by the way, is perfectly okay. In fact, I would say it's a rare contract that doesn't have boilerplate. Boilerplate will be your friend as a paralegal, if you decide to go to law school as an attorney. Boilerplate is just standardized language. Listen, there's no reason to reinvent the wheel every time. This isn't a contract isn't a creative writing project. I mean, you know, if Hemingway were to have, you know, stolen lots of language from Fitzgerald or some other great novelist, we would all say, that's awful, that's plagiarism, Hemingway shouldn't have done that. But when it comes to contracts, you know what? We always steal from other people. We steal from ourselves, we cannibalize our own stuff when we use other people's. And guess what? You can. It's fine, it's done all of the time. There's actually form books out there whose whole purpose is to steal, because this isn't a creative writing project. No one gets extra points for having the most wittily written contract or the most creative contract. You actually want your contract to be really, really boring. You don't want there to be any cliffhangers or, gosh, I wonder what they meant by that. No, you want it to be crystal clear and boring. So you want to use boilerplate. You will have developed language in the past and you tweak it to customize it to your terms, the contract that you're working on, but most of it's going to stay the same. So the fact that you're using boilerplate does not mean that it is procedurally unconscionable. It does mean, though, that you need to make sure that it's not written at a highly legalistic level. That's especially true if you're dealing with consumers. Now, obviously, if this is a deal between two big companies and they're both highly lawyered up, then yes, who cares? Use all the legalese you want to. But when you're dealing with consumers, you'll want to make sure that your boilerplate is approachable. So don't be intimidated by boilerplate. Just make it at a level that the reader, whomever the intended reader is, can make it understood. And again, here are some examples of procedural unconscionability. Okay, another category for procedural unconscionability are adhesion contracts. Let me start by saying that the textbook kind of does a little bit of overkill in this area. The textbook makes it sound like, ooh, adhesion contracts are usually not enforceable. No, adhesion contracts are usually enforceable. You know what? We've all signed lots and lots of adhesion contracts. If you've ever signed a lease, guess what? Adhesion contract. Do you have an agreement with your cell phone company? Guess what? Adhesion contract. What is an adhesion contract? It's a take it or leave it deal. When you went to sign your cell phone contract and you looked over and you saw paragraph 47, gosh, I don't really like the terms in paragraph 47. And you turned to the sales rep, you said, you know what, I think I'd like to change the terms to paragraph 47. Here's some suggested language. Are you able to agree to that? That sales rep is going to look at you like you have two heads. What? What do you mean? No, I can't change the language. I don't have that authority. I mean, you either sign it or you don't. You can't change the terms. That's how it works. And so that's what your cell phone contract is. That's probably what your lease was. I mean, there may be some negotiation over, pets or something like that, but for the most part, it's take it or leave it in your apartment contract. Because really, the big executives of the company don't really want that sales rep to be negotiating over the fine points, in part because that sales rep doesn't have the legal training to be able to successfully do that. For another point, if there's 1,000 different varieties of how these contracts are, how is the big organization going to be able to know how to enforce the contract? Just presents so many problems of scaling up and making sure that they're in constant compliance with all these different iterations. Just completely unmanageable. So adhesion contracts are very common, nothing in the world wrong with it, but they do present a possibility of problems because it does have this element of take it or leave it. They're not being negotiated over. One party is saying, this is the deal. If you like it, great. If you don't like it, go away. But don't think that all adhesion contracts are unconscionable, or even most are. Most of the time when you're dealing with adhesion contracts, there have been a whole team of lawyers who've gone over the contract and have really done a lot of research to make sure that it is going to be enforceable. But an adhesion contract that is a take it or leave it type of situation, and it also has overreaching, may actually cross the line into unconscionability. So what is overreaching? And if you think to yourself, I mean, literally, it means somebody grabbing something that doesn't belong to him or her, right? Reaching across the table. Maybe you're at the Thanksgiving dinner and the person three plates down from you has something on his plate that looks tasty to you, and you reach over and grab it. Well, guess what? You're liable to get your hand slapped. That would be overreaching. And that's what you could have in an adhesion situation where the AT&T or Sprint or T-Mobile or whatever the company is throws in some real whoppers into the contract that really are pretty darn unfair. And guess what? They can do it because no one's going to actually read the contract, and it's a take it or leave it situation. So when they do overreach, and these would be examples of that overreaching, the courts might say, well, given the fact it's a take it or leave it, and we have this overreaching, maybe it is unconscionable. So what are the things that qualify for overreaching? Well, these would be very harsh terms. For example, a lot of penalties for very small violations. Maybe paying your cell phone bill a day late means that you owe double what you ordinarily would, for example. One-sided bargaining power. Let's say in this market there's only one cell phone company. If you want a cell phone, you got to go with that company. Well, that wouldn't be very fair. In a market where we have lots of options, cell phones, you wouldn't have as much bargaining power. It wouldn't be a monopoly. Pre-printed forms, well, of course, you're going to have that with many cases. So I wouldn't call this an especially serious overreaching. Fine print. Fine print we use kind of in a couple of different ways in law. Number one, we use it to mean all of the fine details. And sometimes we mean it literally, that person is using a really small point to their font. Here, we're really talking about the small font, something that's hard to read. Maybe it's on like kind of an onion skin, kind of thin paper, and it maybe even the text kind of bleeds through, and so it presents just difficulties just even understanding it. And that goes back to because of the illiteracy, infirmity, or language barriers, when you can't actually understand the terms. Legalese, again, this would be throwing in a lot of Latin or having really a convoluted sentence structure, sentences that go on for pages, for example, that would be very, very difficult for a non-legal professional to make sense of one way or the other. These would be indications that you might have an adhesion contract that is unconscionable. Okay, so we've talked about procedural unconscionability. Now we're going to talk about the second flavor of unconscionability, which is substantive. And this is probably the more common category. So what is substantive unconscionability? Well, substantive, first of all, it's the adjective form for the word substance. Right? So the substance of something is, what is it made of? You know, the substance of a milkshake is milk and ice cream, maybe a little vanilla, maybe a little bit of fruit. The substance of a sugar cookie is flour and maybe some butter and some sugar and maybe some vanilla and maybe some kind of leavening agent. So that's what we're thinking about when we're talking about substantive unconscionability. So here we're actually looking at the terms of the agreement. We actually need to know the deal in order to have a substantive unconscionability. So what is the definition? Substantive unconscionability is a circumstance in which the contract terms are overly harsh or oppressive against one party. And again, this is the more common category. And even when we have procedural unconscionability, usually there's some substantive unconscionability lurking there. Because after all, if everything was fair and even-handed, then why did one guy try to hide the ball by having a procedurally unconscionable contract to begin with? One category of substantively unconscionable contracts can be installment contracts. So first I'll talk about what an installment contract is, and let's talk about how it can be unfair. An installment contract, again, this term is in red, so you want to know about this one. It's a contract that requires or authorizes the delivery of goods in separate lots. Now, there's nothing unconscionable inherently about an installment contract, but many installment contracts have provisions in it that open up the door for the allegation of unconscionability. Let me give you an example. Imagine that this is a contract where Bob is selling to Larry 1,000 widgets a month, and the contract starts in January and it's going to go through December. So every month for the next 12 months, Bob is going to ship 1,000 widgets to Larry, and Larry will pay Bob $1,000 upon delivery. He has to pay within, it's supposed to be delivered on the first Monday of the month, and Larry is supposed to pay by that Friday. Okay, that's how it works. And if the Monday is a holiday, then the delivery is on Tuesday. So that's the installment contract. As I stated, sounds perfectly reasonable, nothing unconscionable about that. But let's say it has a provision in it that if Larry is a single day late making a payment, then all of the payments are immediately due, even for the product that hasn't even arrived. So let's say in March, Larry doesn't get the check off until the Monday following the Monday that it was delivered. So it's 1 business day late, 3 calendar days late. And so now Larry doesn't owe just $1,000 for the March shipment. He owes March, April, May, June, July, August, September, October, November, December. Instead of owing $1,000, he owes $10,000. Making all the payments due at once because of a late payment is one of the features that isn't unheard of by any means in installment contracts, and that can definitely be unconscionable. There can also be an exorbitant interest rate, for example, that could happen. So here are some examples of substantive unconscionability that we might see in the terms of a contract. Excessive price terms. Usually widgets go for $1 a piece, but in this contract it's going to be $10 a piece. One-sided remedies. Bob can sue Larry for pretty much anything, but there's an exculpatory clause in the contract that very much limits the bases that Larry can sue Bob. When it's lopsided like that, then that is potentially substantively unconscionable. unduly harsh consequences for breach, such as Larry being just 2 days late or 3 days late on payment, and then he owes suddenly $9,000 more than he otherwise would. So what does a court do when it finds a substantively unconscionable contract? Well, again, the bar is very high. The court is looking to enforce the terms of a contract. It's not looking to find a contract unconscionable, so the plaintiff is going to have to get over a pretty significant burden just to persuade the court. But if the plaintiff does persuade the court has some choices. The court can rescind the entire contract, or the court can remove the portions of the contract that the court finds unconscionable. It can either remove it entirely or rewrite them so that they are conscionable. So the court has a lot of flexibility about how to go about solving that particular problem. So let's contrast the two types of unconscionability that we've talked about, procedural and substantive, and really those are the only two that exist. These are the two buckets that we have. So when something is procedurally unconscionable, it means that one of the parties, the party suing, the plaintiff in this case, doesn't understand the contract. Again, it's written in a language that the party doesn't understand, or it's written in excessive legalese or something along those lines. So examples of this would be, due to its complexity or the party's lack of knowledge, literacy, good health, or language skill, that one of the parties just doesn't understand what he's signing or she's signing. Now let's consider the other category of unconscionability, substantive unconscionability. This is focusing upon the substance of the actual terms of the contract. So we're looking at something that seems really unfair. And again, the terms have to be highly oppressive or overly harsh, not merely one-sided, but extreme. That's when you're going to have substantive unconscionability. Again, this would be an imagination. This is the dominant party. This is Bob. He's shaking Larry for all the money Larry has. That would be substantively unconscionable. So let's talk about some ways that this plays out. Let's look at default provisions. Obviously, a default happens when one party doesn't do what he was supposed to do. When a party doesn't perform its obligations under the contract, it's in default. It's in breach of the contract. It makes sense, by the way, in virtually any contract to cover the possibility of one or both parties actually breaching. I mean, you don't want it to happen. You hope it doesn't happen. Most of the time it doesn't happen, but you have to anticipate. You want to anticipate all of the possibilities that seem even remotely possible, and address those and figure out what's supposed to happen. You do not want default provisions to be punitive, so not like the spanking scenario. What you want instead is that the defaulter, or the person who is being defaulted against, so the victim of the default, is not disadvantaged. He's not in a worse position because of the default that he would have been in if there had been no default. So we want the wronged party to be in as good position as he or she would have been in before the contract. It shouldn't be punitive. The wronged party shouldn't be better off because of the goodies he's going to get as a result of the default. We don't want that. Punitive default provisions can definitely be held to be unconscionable. Now, this can be tricky because nobody has a crystal ball. They don't know exactly how things are going to play out. And so, 20/20 vision is always, hindsight is always 20/20 vision. And so things that when you were drafting it might have seemed fair and reasonable, in the actual way the facts play out, they may come across later on as being punitive or unconscionable. And so it's the court's job to kind of go back mentally to the time the parties were negotiating the contract and look at what the parties knew at that time and what seemed reasonable. And that's the standard. What was it punitive when it was created? And if it was, then it perhaps is unconscionable. But if it wasn't punitive at that point in time, and it only seems punitive now, then it's really not unconscionable at all. But if a court does find a default provision to be unconscionable, again, it can strike it out completely, or it can rewrite it so it's no longer unconscionable, or it can decide not to enforce the contract at all, rescind the entire contract. And again, that's going to turn upon the court's judgment and also how the actual deal is structured. So you're actually looking at the contract to see, is it really possible or practical to carve this off or treat this differently than the rest of the transaction? Another way that we oftentimes see, or not often, but sometimes see unconscionability is when you have interest provisions. Now, again, these are very, very common to have interest provisions. If I'm late paying, then it's very likely that there will be some provision that says I have to pay, 10% per annum or whatever the number is for every day that I'm late. After all, why should I get an interest-free loan from the party to whom I'm contracted with? But obviously, the interest rate that is established in the contract cannot violate the state's usury laws. It can't be in excess of that level. If it is, then we have a couple of problems. One is that the contract is probably unconscionable, or at least potentially unconscionable, but also it's going to be a violation of state law. We'll talk about that when we're talking about legal object later on, but that's where we're getting at when we're talking about usury laws and interest provisions. So you want to make sure that you are following state law in this area, because this is all driven by state law. And state usury laws, by the way, are quite complex, so it's something that you have to spend a little bit of time to make sure that you are in compliance. And a smart way to structure it is to say, this is the interest rate, and you might even include a provision that says, or but not to exceed the lawful limit of the state law or something like that. So some kind of savings provision that you might put in the contract. Remedy provisions are very, very common. These are oftentimes liquidated damages provisions. These are very smart to have, so they're nothing that we want to avoid. In fact, we want to actually affirmatively seek these out. It makes a lot more sense for the parties to decide how much should be paid or how that amount should be calculated than to have some judge or some jury who's really divorced from the circumstances of the relationship to make that decision. So it makes a lot of sense to have a liquidated damage provision, but you want to make sure it's not punitive. So if I breach the contract and it costs the other guy $10,000 because I breached, we don't want to award him $100,000. That's not reasonable. But again, we've got the problem of the crystal ball. We don't have one. If we did, heck, if the other guy knew I was going to breach, he probably wouldn't have. If he would used his crystal ball and seen that I was going to breach, he wouldn't have entered into the contract with me anyway. So we have to look at what we knew at the time the contract was signed to see, was that a reasonable prediction of what the damages might have seemed like? And the court's not going to get involved in a lot of second guessing, because the court knows, hey, nobody has a crystal ball. Did that seem reasonable under the circumstances? And that's the test that the court is going to have. If the remedies are really, really super generous to one side or super limited to the other side, then that could be a situation the court could find it unconscionable. And we talked about this with respect to exculpatory clauses in an earlier section of this lecture. Let me just go back and find that one. That might have been back in the first lecture. I think it's useful to spend just a second. Here we go. So on slide 11, we have a definition for exculpatory clause. It's a clause in a contract excusing a party from liability for a wrongful act. And again, when courts find exculpatory clauses unenforceable, it's usually not in the misrepresentation category. It's usually in the unconscionability category. So I don't really agree completely with where our textbook puts this term, but wherever you put it, these are certainly things that the courts look at with a little bit of skepticism. Wait a second, if you do something wrong, you ought to have to pay for it. You ought not get out of jail card free just because you have a contract that provides that type of remedy for you. So now we've covered the 6 categories of things that can happen to destroy or fail to create mutual assent. We talked about fraud, misrepresentation, mistake. Today we've talked about duress, undue influence, and unconscionability. And again, here is our schema. We talked about the 4 elements of contract, the first element being agreement, second element being consideration, third element being legal capacity, fourth element being legal object. Occasionally we need a writing, but it's not always necessary, so we're not going to put that as a 5th element. Under our element of agreement, we have 3 sub-elements. We need to have an offer, we need to have an acceptance, and the acceptance has to demonstrate mutual assent. And let's just go back here for a second to our first slide. Or not first slide, but one of our first slides. Here we go. And this is the part that we added in this chapter. We've talked about offer and acceptance and mutuality of assent all being part of the agreement element. So this stuff in red is what we covered today. You'll find this information not in the PowerPoint, but you'll find it in a separate tab in the chapter. So this information is available to you. This is a kind of a good way of connecting all the various pieces of this particular topic, showing its connection with the other topics that we're covering. So let's consider some practical applications. Okay, so when you're dealing with fraud, misrepresentation, duress, and undue influence, you have to think about the entire context of the relationship. And so you want to, you can't necessarily just review the contract and say, oh, doesn't seem to be any fraud in this contract. Well, most of the time, if there is fraud, it's not going to be documented in the contract. It's going to be something that's orally spoken or communicated in such a way. So when you are advising your client about how to avoid these things, it's not going to be a smoking gun. It's going to be a much more subtle aspect. So you'll have to ask questions. Now, what commitments were made? Well, what is the relationship between those two people? Well, what kind of due diligence did you do before you answered those questions? Those types of things are the things you'll want to get at to avoid these types of problems. Let's talk about mistake a little bit. Again, the lecture that we had, or the first lecture on this chapter, covered this in more detail. But things that you want to think about are clerical errors. The typist, you know, proofreading it to make sure that, I mean, these types of proofreading errors are not big deals, but when you're talking about quantities or payments or dates or amounts, things like that, you'll want to be very careful about that and carefully proofread documents and contracts. This is also important when you're using boilerplate, when you're cutting and pasting from the document, because it's easy to keep some of the language from the previous agreement in yours. You know, if for example, there were two men entering into a contract, so your pronouns are all he's, but maybe in this next contract there's a man and a woman entering the contract, so some are he's, some are she's. Well, you want to clean that up, and that can be a reason, by the way. You may not want to use pronouns. You may want to stick with the actual names of parties. So that it's a little bit easier to go through and proofread, because if you're going through to look for he's, you're going to have to look for his, him, he, himself, you know, and kind of do a little bit more of the word search to get everything out of the way to make sure that you've eradicated all of the pronouns that are inapplicable. As you're considering the issue of unconscionable terms, here's some things you may want to ask yourself. Is the effect of a particular term intended to punish? Obviously, if it is, then that's an indication you may have an unconscionability problem. Do the parties have freedom to negotiate? It's a good idea to allow one party to be responsible for at least one part of the deal, drafting it or having some control, and even to document that. It may be a small part of the deal, but if you can show, hey, you know, Larry changed the delivery date. Bob wanted it to be at noon, and Larry said, let's make it 10 a.m. Okay, guess what? There's been some negotiation. Larry has contributed something to this deal. That's a good fact. And that can be a good thing to document, actually, in the agreement. Events that could lead to a default is a cumulative effect. Fair. Again, if you have some kind of acceleration provision, is it fair under the circumstances? Is the interest rate compliant with state usury law? And are certain remedies excluded? Again, that goes back to the exculpatory clause idea. And if they're excluded, why are they being excluded? And what remedies are remaining to the party, the wronged party, if in fact the remedies there is a breach? I hope that this presentation has been helpful. As always, if you have questions, come to my office hours or send me an email, and I'll be glad to help figure out what we need to spend more time on so it all makes sense. I thank you for your attention, and I hope that you have a wonderful day.